Good day, Prime Minister. My name is Jeffrey, and I'm your legal advisor. Today, I will address two key matters regarding the International Covenant on Civil and Political Rights, known as ICCPR, and its first optional protocol. I will explain what the first optional protocol provides for and its impact on Mandela. Additionally, I will discuss the concept of reservation and whether Mandela can enter a reservation to Article 1 of the first optional protocol, as suggested by a member of the cabinet. So to start, I will be introducing what is ICCPR. The ICCPR, adopted by the United Nations General Assembly in 1966, aimed at safeguarding civil and political rights globally. These rights include fundamental freedom, such as rights to life, freedom of speech, freedom of assembly, electoral rights, and the rights to a fair trial, among others. The purpose of the ICCPR is to ensure that individuals enjoy these rights without discrimination, thus promoting universal respect for an observance of human rights and freedoms. The ICCPR is complemented by two optional protocols, which the first of which we will focus on today. The first optional protocol to ICCPR was also adopted in 1966. It served as a critical adjunct, or what we call as a supplementary treaty to the covenant, by establishing a mechanism for individuals to submit complaints about violation of their rights. Specifically, the first optional protocol allows individuals who claim to be the victim of a violation of their rights set forth in the ICCPR to bring their complaints directly to Human Rights Committee, provided they have exhausted all available domestic remedies. Well, this process involved the submission of a written communication to HRC, which then examines the complaint and issues findings on whether a violation has occurred. The state concerned is expected to provide remedies if a violation is found. Due to its flexible nature, it allows states to choose whether to accept these additional commitments, reflecting a voluntary enhancement of their human rights application. If Mandela chooses to become a party to the first optional protocol, Mandela must recognize the competence of HRC to receive and consider individuals' complaints. This will increase the accountability of the state for its human rights practices and provides a mechanism for individuals to seek justice at the international level. Talk about the impact on Mandela. There are some positive impacts and challenges upon acceding to the first optional protocol. For instance, it would strengthen Mandela's commitment to human rights by upholding the international human rights standards. It would also help enhance Mandela's international reputation by demonstrating itself as a state that respects and promotes human rights, potentially improving diplomatic and economic relations with other countries. In contrast, Mandela may face an increase in complaints from individuals alleging violation of their rights, which would require extra efforts in the sense of management and response. Moreover, Mandela would also need to ensure its domestic laws and practices fully comply with the standards set out in the ICCPR to avoid adverse finding by the HRC. For Mandela to join the ICCPR, it is essential to talk about the concept of monism and dualism. If Mandela follow a dualist approach, it would need to enact domestic legislation to implement the ICCPR and the optional protocol fully. While if Mandela practices a monist system, these international agreements would become part of Mandela's domestic law upon ratification. Next, as suggested by a member of the cabinet, should Mandela consider entering a reservation to Article 1 of the first optional protocol? It is essential to understand the concept of a reservation in international law. According to the Vienna Convention on Law of Treaties, VCLT, Article 2, Clause D, a reservation is a unilateral statement, however phrased or named, made by a state when signing, ratifying, accepting, approving, or acceding to a treaty whereby the state proposes to exclude or modify the legal effects of certain provisions of the treaty in their application to the state. In other words, reservations allow states to accept a treaty, while making certain modifications or exceptions that they deem necessary to align with their domestic laws or policies. However, as later mentioned in Article 19 of the VCLT, a state may formulate a reservation unless the reservation is prohibited by the treaty. The treaty provides that only specific reservations may be made, or the reservation is incompatible with the object and purpose of the treaty. To illustrate, in the case of Belilius against Switzerland, the European Court of Human Rights found that the reservation made by Switzerland to Article 6 of the European Convention on Human Rights was invalid, as it was incompatible with the Convention's object and purpose. Besides, according to the General Comments number 24 by the Human Rights Committee, the committee states that reservations that are incompatible with the object and purpose of the ICCPR are invalid, emphasizing the importance of preserving the integrity of the treaty. In the context of First Optional Protocol, the object and purpose of the treaty is to allow individuals' complaint to be heard by the HRC, while Article 1 of the Optional Protocol expressly states that individuals who claim that any of their rights enumerated in the Covenant have been violated and who have exhausted all available domestic remedies may submit a written communication to the committee for consideration. A reservation made to Article 1 would essentially undermine and nullify this mechanism, as it negates the protection of human rights of the Mandela citizens. If Mandela were to enter a reservation to Article 1, it could be invalidated by other states, and the HRC might object to such a reservation, arguing that it undermines the primary function of the protocol. Hence, it is unlikely that Mandela can legally enter a reservation to Article 1. Given this consideration, it is advisable for the Prime Minister of Mandela not to enter a reservation to Article 1 on the ground that such a reservation is generally deemed impermissible. If, by any chance, the State of Mandela joined as a party to the First Optional Protocol and enters a reservation to Article 1, it is important to talk about the doctrine of severability. The severability doctrine in international laws refers to the principle that allows for partial acceptance or rejections of reservation made by states to treaties. This means that a reservation can be considered severable from the main body of the treaty, allowing the states to remain bound by the treaty except for specific provision to which it has reserved, provided that the reservation is not incompatible with the object and purpose of the treaties. In other words, if a reservation is found to be invalid because it is incompatible with the object and purpose of the treaty, the reservation may be also severed in the sense that the states remain a party to the treaty without the benefit of the reservation. To illustrate, in the case of Belilius against Switzerland 1988, the ECHR dealt with a reservation made by Switzerland to the ECHR. Switzerland had reserved the rights not to be bound by a specific provision regarding the rights to a fair trial. The ECHR later found that the reservation was incompatible with the object and purpose of the convention. Hence, the court severed the reservation, maintaining Switzerland's obligations under the convention without the benefit of the reservation. Similarly, in the case of Lozidal and Turkey 1995, Turkey had made a reservation to the ECHR regarding its jurisdiction over certain territories. The ECHR then ruled that the reservation was incompatible with the convention's object and purpose. The court later severed the reservation and held that Turkey was still bound by the convention without the reservation. If Mandela's enter a reservation to Article 1 of the Optional Protocol, it is likely to be deemed invalid if it undermines the core purpose of allowing individuals petition. This could lead to reservation being severed and Mandela's will still be bound by the Optional Protocol without the benefits of each reservation. In a conclusion, Acceding to the first optional protocol of the ICCPR will enhance Mandela's human rights framework by allowing individuals to seek redress for violations through the Human Rights Committee. However, entering a reservations to Article 1 would likely be incompatible with the protocol's objectives and could be invalidated, undermining Mandela's commitment to human rights. Therefore, it is recommended that Mandela join the protocol without reservations to fully align with the international human rights standards and strengthens its global reputations by upholding the standards of human rights and striving to combat human rights issues that may arise. Thank you for your attention.